Today, the 21st of January 2025, members of Justice4Patients filed a claim with the Supreme Court of the Falkland Islands in respect of breaches of our constitutional right to privacy and family life. The basis of our claim is the emotional harm and distress caused by the unauthorised access to our medical records and the medical records of close family members by staff in the medical department. In addition, we seek to highlight the failure by FIG to prevent such unauthorised access from occurring in the first place, and the weak and ineffectual response from the government once the data breaches were discovered.
Our demands are simple. Number one, a full, detailed and sincere public apology from FIG to everyone affected by the unauthorised access to their medical records. This apology must acknowledge the harm caused by breaching our fundamental right to privacy. Number two, FIG must commission an independent public inquiry into the circumstances of the breaches in order to understand what went wrong, the extent of the damage caused, how FIG responded once the breaches were discovered, and to make recommendations to prevent this happening again.
I will never forget when Barry first told me that my medical records had been looked at, and at that stage we didn't know by whom or how often. I just felt like I'd been felled to the ground. It feels like a burglary. I think if you've ever been burgled, you've had this awful feeling that somebody has broken into your house, broken into your car, taken your wallet, they've taken stuff. And it feels like that, but it's about 100 times worse, because what these junior members of staff took is information. And that information was given on trust, in confidence, by me or other patients to healthcare individuals, and quite often when those patients were feeling at their most vulnerable. It's the most ghastly feeling, and although I've had it now, lived with it for 6 years, I still think twice about going to the hospital. I trust some members of staff. I'm quite happy to see them. But there's always this thought, who else is looking at my medical records and why?
I became involved because my daughter and her son got a letter to say that their notes had been accessed. Following that, I asked if I could have an audit trail on my son Dan's notes, who we lost in an accident in 2012, and on asking for this, we found that his notes had been accessed by the two girls, and also several months later we found another member of the staff, a higher member of the staff, in the hospital as well.
There was an internal investigation at KMH, the outcome of which was a letter to us after 4 months saying, oh, it's all been sorted, lessons have been learnt. And when I asked for meetings to find out what lessons have been learnt, I was told, no, there's nothing further to discuss. And we have never been offered meetings by anybody at the hospital. We have had meetings with the chief executive on issues around this, but no, we've never had anybody say, oh, terribly sorry, what an awful mistake this is, let's come and sit round the table and talk about it, which is what they should have done.
You are dealing with the most confidential data possible in medical, and you need to be sure that your systems are in place such that that information cannot be read by people who shouldn't be reading it, for all the reasons that Anya has just explained. And clearly it's happened on 2 occasions that we know of. It shows that the procedures and the policies that the hospital had in place at the time were totally inadequate.
One of the things mentioned in yesterday's statement was the highlighting of the failure by FIG to prevent the accessing of data in the first place.
Yes.
What kind of failures are you referencing there? Is it training? Is it supervision of staff? Is it the software that staff had available? Or is it the staff themselves not being made aware of what data they could access in the first place?
I think it's all of them. It's quite simply all of them. A lot of this came out in the first court case, unfortunately what came out was the lack of training. in the first case, and that was mentioned, I think, in the final summing up. The hospital have been saying and issuing statements about the software that they use. It's not an adequate computer program. I've used it, it's not great. But my contention, and I have said this to MLAs, is that any computer system is only as good as the people using it. So if you give a very junior member of staff the same level of access to medical records as a qualified staff nurse, and then leave them to it without supervision, without adequate training, and without monitoring them, you're still going to have the same problem.
Mistakes happen, odd things happen, but it's how you respond. And I come back to that fact of, gosh, something's odd. Tell you straight away, yes, of course we'll look to see who's looked in your notes. Oh my gosh, something awful's happened. This is what we're going to do. That's how a good organisation will respond. That's how a chief medical officer should respond. I see there's been a press release today from government, and in it they say they have been and continue to be open and candid. That phrase is from the General Medical Council and the Nursing and Midwifery Council that tells people who are registered as doctors and nurses in the UK, you have a legal duty to be open and candid with people when things go wrong. We never received any openness or candour at all.
And government in general have treated every patient whose notes were accessed with contempt and disregard. It's proved to people that they don't matter. Their feelings don't actually matter, which I think is a disgusting attitude for them to have. They may not have done it particularly knowingly, but that's how it's come across.
So we've had legal advice not only locally but from the UK, which have suggested that, based on the information they've all been given, that it is a valid case in terms of the Falkland Island Constitution, but also in terms of human rights. And also because I just believe what has happened and the way it's been handled in the hospital has been wrong. And I base that opinion, which is my own opinion, on regulatory standards from the General Medical Council, the Nursing and Midwifery Council, but also advice from my medical protection, medical indemnity providers.
It's a big step, what we've taken, not just appealing to the Supreme Court, but also contacted the Minister. I served for 10 years as an MLA, and we all want the Falkland Islands to be in charge of their own future and really to run our own country. But there are safeguards. One of those safeguards is the Governor and the Minister in the UK, who has final responsibility to ensure that the overseas territories are being governed correctly. And so we have appealed to the Minister to say, look, we believe we haven't been treated well here. We don't think due process has been followed. We believe there's been a cover-up. And we've asked him to review the Governor's refusal to call an independent inquiry, to look at the evidence and take it from there. It's a big step.
All of us in Justice for Patients are very aware that this is a huge step. People are not in the habit of taking governments to the Supreme Court on things like this, and certainly not here.
They could have met with us a couple of years ago, a year ago, and this whole thing would have been gossip for 24 hours and then fizzled out. If they'd apologised, it would have been done with. But they haven't bothered to do that, and I think they've treated us all, especially everybody who had their notes accessed, they've treated them with contempt, and that's not the way to be.
Is the group asking for anything else to be done by FIG in regard to the individuals who had committed the two breaches? After all, both cases have already been to court.
No. And I think we want to make that very clear, because I'm sure that there are people in the community who think we're on a bit of a witch hunt. I'm quite careful not to mention names, because I don't, they are living with the consequences of their actions. And in some ways, I think that they were also victims of a lack of training, a lack of supervision, and a degree of arrogance in the hospital from senior staff who just didn't supervise them enough.
An apology needs to be fulsome, it needs to be immediate, it needs to explain to the people who have been affected what went wrong and how we are going to put it in place. None of that has happened. We've had to drag that apology. That September, the apologising for the apology that wasn't an apology. That's farcical. It puts government in a bad light, puts the medical department in a bad light. And it doesn't need to be like that. They can recover from this if they are, as they said they're going to be, open and candid. But we haven't seen it yet.
When asked for a comment on the claim filed by Justice4Patients, an interview was declined by FIG. However, 2 public statements were released this week. FIG's public statement states, "The Falkland Islands government acknowledges the claim filed by the Justice4Patients group with the Supreme Court of the Falkland Islands. In September last year, the King Edward Memorial Hospital provided a detailed update to the public in relation to actions taken in respect of patient data breaches. A wide range in improvements in how KEMH handles confidential patient data have been introduced, and further changes will also be implemented, including an upgrade to the KEMH's electronic patient record system. The update acknowledged the worry and distress that these breaches have caused. The KEMH and FIG was and remains very sorry that these breaches occurred. Members of the public will be aware that the KEMH commissioned an inspection of certain hospital services last year. The report has been received and will be published shortly. And on the matter of confidentiality, it notes significant improvements were made to internal processes and procedures around accessing patient data following recent data breaches. However, it was also found that there was a notable level of anxiety among staff who felt they may get in trouble for legitimately accessing patient records. This highlights the necessity of maintaining proportionality in the KEMH's responses. The KEMH and FIG have been and will remain open and candid about these breaches, committed to improvement and fully cooperative with any legal processes, whilst at the same time ensuring that staff are fully supported in appropriately using patient data at all times."
The public statement from members of the Legislative Assembly says, "We are aware of the claim filed by members of Justice4Patients with the Supreme Court of the Falkland Islands regarding data protection breaches. We recognize that privacy and confidentiality are vital issues, particularly in healthcare settings. We are committed to upholding these principles. We know that there have been data protection breaches in the past, and we would like to take this opportunity to again say how sorry we are for this, and to reiterate our commitment to continuing to support staff to improve our processes."